Welcome to Spring Tea with Carolyn Walshlaw. My tea today is not Irish tea, it's lemon ginger and it is delicious. Today we're going to talk about probate and answer that question, what the heck is probate? Many of you come to me saying one of the aims of your estate plan is to avoid probate. That's because you've heard that it's a bad thing, or you've just been unfortunately educated through a family member having to go through probate, the estate going through probate, and you've kind of got to see how messy and public and long-winded and expensive that is. So probate is a court process, and really it's a way to switch title. If we pass with something in our name only, no beneficiary, no trust, no joint tenant, there has to be a legal way for that to go to whomever it would naturally belong to, whom the law would determine it belongs to. So when we die with either inadequate planning or no planning, there has to be this process. And the process is filing a petition, opening up a probate, having an administrator appointed, publishing claims notices, getting letters of office, keeping it open for 6 months here in Illinois, all the lead up to the open, the administration during it, and then the closing afterwards. It's typically about a 1-year process. It typically costs, and let's say we have a home and a large account, maybe a car, some personal property. The cost is typically $7,500 to $10,000, maybe about $1,200 with court costs and filing fees. And then if we have no will and we have to file a bond, that's another $1,500. And if it goes on after that full year, then we have to renew that bond and pay it again. So let me give you a couple of stories, examples when a probate might be needed. So mom and dad hold almost everything jointly. They have their home jointly. They have an investment account jointly. They have their bank account jointly. Mom would stay at home. Dad worked for many years. His 401k rolled into an IRA. Dad passes away. Home is fine. Investment account is fine. Bank account is fine because mom's a joint tenant. But it's discovered that the IRA moved from one financial house to another and had no beneficiary. The IRA is $200,000. Anytime you go over $100,000 in the state of Illinois, you have to take that as to probate if there is no beneficiary. So that's what would have triggered the probate in that case. Fast forward now many years, mom got a will because now she doesn't have a joint tenant because her husband has predeceased her on the investment account, the checking account, or the home. So then upon mom's death, the family feel, well, mom had a will, we're all going to be fine. And then they discover that there was a beneficiary this time on the bank account, there was a payable on death, there was a beneficiary on the investment account, but the home, mom and dad's name only still. Mom and dad are both gone. A will says mom and dad leave everything to their 5 children, but we need a legal mechanism to change that title, and the will does not do that. So we have to go to probate court with that will. And I will tell you, it's often a home that triggers a probate. So in my office at this minute, we have 12 probate cases going through court. 8 of them have been triggered by a home. 4 of them by a large account that didn't have a beneficiary on it. Now, that's not 12 families that did no planning. There were 4 of them that did no planning, but there were 5 of them that had a will but no trust, hence the home having to go to probate. And then we had a few with a will and a trust, but the trust wasn't fully lined up with the assets. So it's unfortunate when we have to go into probate because there are many ways to avoid it. And if you just keep these 3 things in mind, if you have a joint tenant on an account, it's not going to trigger probate. If you have a beneficiary or a payable on death on the account, it's not going to trigger probate. Or if you have a trust. And I will tell you all of those cases that are in probate because of the home that's going to cost maybe between 10 and 15,000 to get out the other side of that could have been taken care of with a $2,000 trust. Estate planning is an investment. It's an investment of your time and your money at any time, but it's a stitch in time saving nine. So if I ask any of my clients, would you rather pay $2,000 now? And these are these are just examples. These costs could be higher or lower on each end. $2,000 now to get the trust, have the property protected, go to your children privately, or pay $15,000, have it go through a public process, have a claims notice put in the paper. They are going to choose that private, much faster, much smoother, less hassle on the family during the difficult time when parents have passed. They're going to choose that earlier route, that stitch in time every single time. So probate is not a monster. It's a very necessary legal process that's in place, because I will tell you, and this might surprise you, and you may have heard me say this before, but almost 50% of people still don't have any estate planning done at all at their death. So those probate courts are very, very busy. Right now, we're not getting hearings for maybe 6-8 weeks out because those courts are backed up. But you can avoid all of that. There's many ways to avoid it. The most common one for my clients, for people just like you, is a trust. That is your food for thought for today. I am going to leave you with a quote from Mark Twain, and that is, "The fear of death comes from a fear of life. Those who live their lives fully are prepared for death at any time." So here's to living fully in our lives every single day. Keep enjoying the spring, and I will see you next Friday with Curlin Moss Law Spring Tea. Thanks and bye.